Okay, a very good afternoon, one and all. I am Anu Bhatnagar, Webinar Executive, and I welcome you all for this amazing session on presumptions under Indian Evidence Act. This session is organized by Law Seekho, and this session will be helpful for advocates, academicians, and law students. So, basically, today in this session, we'll be discussing about the classification of presumptions under the English law as well as under the Indian law. What are its related provisions under the Indian law, right? Secondly, we'll discuss what is the impact of these presumptions of what are the impact of these provisions of presumptions on the degree of requisite required criminal cases, matlab how to prove these, right? And some of the other legal aspects we'll discuss in the upcoming session. So I believe this session will going to be very informative. So stay tuned with us till the end of the session, and we'll take your query in the end of the session, right? So to give insight over the same, we have with us Advocate Rajiv Joshi, sir. He is an advocate at Punjab and Haryana High Court. So we welcome you, sir. And Neelam, could you please unmute him?
Yes, thank you.
Yes, we welcome you, sir. And before we start our session, let me just quickly tell about our speaker. Rajiv sir is a practicing advocate at Punjab and Haryana High Court since 2001. He is having a 2 decade experience in the field of law, and also he has dealt with cases such as civil, criminal, revenue, and the consumer laws. He was also connected to the Council on behalf of farmers of Punjab, assisting the state consumer dispute redressal. Apart from this, he is also having a good hold over discussion on academicians and legal professionals and law students. So we welcome you again, and we have a lot to learn from you, sir. And without any further delay, let's start with our session today. Over to you, sir.
Thank you so much, Anu. Uh, Today we'd actually dwelled upon the topic of presumptions in the Evidence Act, and the presumptions under the Indian Evidence Act, as we all know, are very important in the criminal trials and many other proceedings. Uh, we have basically presumptions divided into 3 degrees, and it all commences from Section 4 of the Indian Evidence Act, which will define what do we mean by may presume and shall presume, and then conclusive proof. In all the presumptions that are delineated in different sections, different provisions of Indian Evidence Act, we find that either there's a use of word may or there's a use of word shall. Basically, there's a difference, and the definition will give throw some light upon how the courts will keep on changing the degree from may to shall. So whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved, number one, proved, and unless uh, and until it is disproved, or call for the proof of it. So the first category of presumptions will include those where the court will presume a fact to be proved, or unless and until it is disproved, the court will presume its existence, and or may call for the proof of it. This calls for the discretion of the court. Now the second is shall presume. Whenever it is directed by this act that the court shall presume a fact, and we will read many of those sections, it shall it shall regard such fact as proved unless and until it is disproved. Now here the degree of presumption is has increased. The presumption is now a little more strong than what it was in the earlier part. So unless and until it is disproved, the court shall presume the existence of those facts. Now, the third is a conclusive proof. when one fact is declared by this act to be conclusive proof of another. The court shall, on the proof of one fact, regard the other as proved, and shall not allow evidence to be given for the purpose of disproving it. This is conclusive proof. One fact is proved, the second fact is held to be proved. You will not get any chance of rebuttal. In case of shall presume, there is a chance of rebuttal. You can rebut. In case of may presume, there can be either you can rebut it if the court draws a presumption, or the court may not draw any presumption at all and may call for the proof of it, or the court draws a presumption that the facts exist, but it is up to you to disprove it. Now, under the English law, we have something called conclusive presumptions. They are rare, but then they are not liable to be contradicted, and that is exactly what we have in the Indian Evidence Act as well. And and then there is a second category of presumptions which are just an ordinary rule of the burden of proof. In those, the gist is that it shifts these presumptions will shift the burden of proof on the other party. And then the third is that those which are regarded in the English law as nothing more than legal maxims, these are rebuttable presumptions. And the lightest one is fourth, bare presumptions of fact. Now these are, you can say, just arguments which can be rebutted by anyone. Under the Indian law, we have this, classification of may presume and shall presume. Now there are various provisions which come under the category of may presume, and there are various provisions which come under the category of shall presume. You have seen the subtle difference as to the rebuttability of the two. In the first category, that is in may presume, you have these sections 82, 86, 87, 88, 88A, 90 and 90A. These are all pertaining to documents, as you all know. And then in shall presume, there are certain documents which shall be presumed. These are 79 to 81, 81A, 83, 84, 85, and then 85A to C and 89. Now, apart from that, there are certain other presumptions. We will keep on discussing those. I also want to discuss few provisions which are outside the Evidence Act, but then there are other statutory presumptions as well, because these run along with the presumptions which are present in the Indian Evidence Act. Those presumptions we draw, there can be special statutes, like we have the PC Act, the Prevention of Corruption Act. There is a presumption. Then we all know Negotiable Instruments Act, in the check bounce cases, there is a presumption under section 118 read with 139. Those are called statutory presumptions, right? What do these presumptions do? These presumptions will shift the onus, they will shift the burden. Otherwise, in the criminal law, the general rule is that the prosecution will prove its own story. The burden to prove a case is always on the prosecution. As you would recall, the famous case of Kaliram versus State of HP, 1984, the Supreme Court has drawn from all these cases that in criminal cases, the initial burden to prove the allegations is always on the prosecution, except the statutory presumptions. For example, in the Negotiable Instruments Act, the presumption is that the accused has given a check in discharge of some legal liability, right? Although there is a statutory presumption, but here also the initial proof of the facts is on the prosecution. Once those facts are proved, then the statutory presumption starts coming into play, and then it is for the accused to rebut those, right? There have been various judgments time and again, because statutory presumptions sometimes are given more importance than they actually deserve. So in 138 cases, usually the trial courts were sentencing a lot of people because there's a statutory presumption. Every kind of story was being accepted, and the accused were handed over conviction. So it was in Krishna Janardhan Bhatt's case that Supreme Court said that even in these kind of cases where there's a statutory presumption, there the presumption is not that of the fact that the accused borrowed a loan. The statutory presumption is that the negotiable instrument was given in discharge of a legal liability, and you cannot go beyond that. So why this confusion about the presumptions? The conclusion, the we try and draw some conclusions that these presumptions are actually conclusive. So therefore, we need to understand that Indian Evidence Act has drawn a very clear line between those provisions which are falling between may presume and shall presume, and that is why I pointed out those provisions which are coming under may presume. So in that case, until it is disproved, those documents will prevail. For example, in section 79 of the Evidence Act, these are the presumptions with respect to certain documents. The court shall presume every document purporting to be a certificate, certified copy, or other document which is by law declared to be admissible as evidence of any particular fact and which purports to be duly certified by any officer um, who is duly authorized thereto by the central government, provided that such document is substantially in the form and purports to be executed in the manner directed by law in that behalf. The court shall also presume that any officer by whom such document proposed to be signed and certified held when he signed it the official character which he claims in such paper. Now, all of you who would be aware of the provisions of Section 219 CRPC, I'm just giving an example. In criminal trials, the previous conduct of the accused sometimes becomes relevant. Normally, it is not relevant, but the previous good conduct is relevant. The previous bad conduct is not relevant, right? So these are sections 53 and 54 of the Evidence Act, which I usually call as the good boy, bad boy sections. So the good boy, bad boy sections, like the previous, if he has been a good boy in the past, it is relevant. If he's been a bad boy in the past, that is irrelevant. Why? The reason is very simple. Because in every case where an accused is brought to trial, the prosecution cannot say, look, he's been committing these thefts time and again, therefore he should be held guilty in this case also, right? So the previous, there is a previous past, there is a past that he has, a criminal past, but under the Evidence Act that is not relevant. Although the accused can take the plea that he has never committed any offense, he's always been a very good citizen, he's been a good boy, so he can take that plea, right? Now there's a provision in the CRPC that whenever somebody is convicted of a similar offense in the past, then you can bring those offenses to the knowledge, the judgment of conviction to the knowledge of the trial court. And if you do that, then 211 and 219 would say that you will have to frame a charge against that person on those allegations, right? Now, why I am talking about these sections? Because the evidence that you need to introduce before the trial court for proving such charges is only a certified copy of the judgment of conviction passed by the earlier court. Now, how is that judgment? You did not lead any evidence to prove that he was held guilty and he was sentenced. You're only giving a certified copy of the conviction. that judgment would be relevant under these provisions of law. That is how these provisions serve the law. They save your time. They save the time of the court. That is why these provisions are inserted. We have all seen that these are the documents which are held to be which are presumed to be genuine, right? There's a presumption. But what purpose do they serve? This is the purpose that they serve. Now, suppose a document had come from abroad, say England or say US. What is the relevance of that document? A power of attorney had come from England. A document was notarized in England and it came to India. Is there any need for the further embossment? Is that document valid? Is that document having any evidentiary value in India? These are the provisions which give you the answer to such questions. Because, see, we all know we can all read what are these provisions. But for a law student, the significance is when he goes to the trial courts and understands the meaning, the real meaning and purport behind these sections. The real meaning is that some of these documents which are mentioned here and they are presumed that the court shall presume it, right? They are meant to save the time of the court, and many times the objection would be taken by the opposite parties. For example, most of the law students may not be aware of the fact that whenever a power of attorney is called for from the foreign countries, then you have to necessarily get it embossed or get a there's a revenue stamp that you pay in the commissioner's office. That's the embossment. That's the fiscal part of it, right? Any document coming from abroad, you have to pay a certain fee. They emboss it, then they'll give it to you. Now, only then that document becomes admissible. But that is only for the fiscal purpose, right? To know the sanctity, the genuineness of that document. But there are certain documents which would be admissible per se because there's a presumption. Our Evidence Act provides so. Section 80 says presumption as to documents produced as a record of evidence. Whenever any document is produced before any court purporting to be a record or memorandum of the evidence or a part of the evidence given in witness in a judicial proceeding. All right. I'll just exemplify. There was a case between A and B. It's a case between a landlord and a tenant. And the landlord admits something, a very vital admission. Now, a certified copy of this statement was obtained. Then there is a case between A and C, another tenant and the same landlord. Can you produce that statement before the court? Yes, you can. Section 33 of the Evidence Act says that you can always confront the party with his previous statements, right? Even otherwise, you can confront a party that this is your previous statement. Now, you have got a certified copy of a statement or a cross-examination of that person from the judicial record. You place it before the court and you say, sir, this is your statement. Now, the procedure in the trial courts is that this certified copy has to be exhibited. Only then it will be taken care of. Only then the Evidence Act, if it is exhibited before the trial court, only then they will examine it. If it is only marked as mark dash dash dash, then it wouldn't be taken into consideration. Exhibited means that the document may have been proved in accordance with law. Mind you, all the documents exhibited on the record are not taken to be proved. Sometimes they are just exhibited like that. But normally, as the trial courts go by the procedure day by day, they don't allow the exhibition of any document without the valid proof of that document. Now, if it's a certified copy with the stamp of the judicial authorities prepared under the Indian Evidence Act, there is a presumption, right? Now, all these provisions that we're talking about, they are coming under the category of may presume, which means the opposite party can rebut it. No, it is not from that judicial record. It is a forged and fabricated. If you can lead an evidence and say, look, I am having the certified copy of that record as well. I have nowhere stated this. Now, how will the court determine? There are two certified copies before the court. How is the court going to determine? The court is going to call the original record, and then it will come to conclusion. All right, this is the original, right? So you can rebut, but if it's a fair copy, if it's actually a certified copy, nobody will question it. That's practical aspect, right? Because the party against whom that statement is being produced, he or she would know that yes, I made the statement before that court, right? So therefore, the convenience demands that such documents should have a presumption along with them. So they are taken on their face value, right? Now, then 81 talks about presumption as to gazettes, newspapers, private acts of the parliament, and other documents. Government Gazette is a very important publication. Where would it be used? Say a land is uh, taken over, acquired by the government, central government. Do you see long advertisements in the newspapers when some land is acquired? You see a lot of, revenue numbers of the properties X, Y, Z, and then, khasra number, khata number, mustil number, this, that village. Half of your newspaper will be covered with that acquisition only, right? Now, if the landowners were to claim the compensation from the land acquisition collector, and thereafter you would know that for the enhancement of that claim, we would file appeals before the district courts, of course, under the provisions of such act, and from against the award of the land acquisition collector. What is the evidence you will give that you had this piece of land XYZ and it was acquired by a notification dated so and so so and so? You did not publish that notification, but the government did. And the government published it in the Gazette as well as in the newspapers. So once you bring on record any newspaper having that Gazette notification or having that notification, then you are probably going to have you're probably going to have a document which will flow under this. The presumption will flow under this section, right? So that's for the convenience. And then presumption as to gazettes in the electronic forms. The court shall presume the genuineness of every electronic record purporting to be the official gazette or purporting to be the electronic. This is just an extension of 81, and that is on the basis of the advancement in technology that now things are maintained in the electronic form as well. Then presumption as to document admissible in England without the proof of seal or signature. This is what I was talking about. When a document is produced before any court, purporting to be a document which, by the law enforced for the time being in England or Ireland, would be admissible in proof of any particular in any court of justice in England or Ireland, without proof of the seal or stamp or signature authenticating it. See, this act came into being in the colonial times. And of course, keeping in view the mother nation, England, these provisions had been, and they are still there. So net result flows that the court shall presume that such seal, stamp, or signature is genuine. Anything comes from England, there is a presumption under Section 82, and it has still not been amended, touched. No. And that the person signing it held at the time when he signed it the judicial or official character he claims. So these are the presumptions, and they help in the trial courts. You have many such documents coming from the NRIs, from the non-resident Indians who prepare these affidavits, GPAs, other documents which are often used in the litigations in India. Then 83, 84, of course, presumption as to maps, and then collections of law, reports of decisions. Every book purporting to be printed or published under the authority of government of any country and to contain the laws of that country. Suppose you were to cite the Constitution of America or any other country for that matter. Then suppose you were carrying a handbook of constitution of a country ABC, and then how are you to prove that? Section 84 will help you. You need not apply for the certified copies, or you need not bring a person from their embassy and prove it, right? This is for the convenience. Presumption as to power of attorneys, 85. The court shall presume that every document purporting to be power of attorney and to have been executed before and authenticated by a notary public or a court, a judge, magistrate, Indian consul or vice consul or representative of the central government was so executed and authenticated. I'll tell you, in many of our cases where the people are residing in Canada or US, as far as England is concerned, the provision is covered under 82. But as far as the other countries are concerned, uh, we have, this Geneva Convention, and many countries are signatories to it. There's a reciprocal understanding between the countries that A country will honor B country's documents, B country will honor A country's documents. So in US they have this apostille system. An apostille will affix a stamp over that document. So what is the way to authenticate? If I were to actually just go by the stamp of an apostle, I will first have to prove that there's a mutual agreement between both the countries. I'll have to show and convince the court there's a mutual agreement. And this is the Geneva Convention, this is the mutual agreement, and this is how this is. But if you want to really just cut the controversy short, you have a document, a power of attorney coming from US, and you want to prove it in an Indian court. The best thing is that go to the consulate general's office, get it stamped from the consulate, and then the document will be covered under Section 85. That's the presumption that flows. Now, is this rebuttable? Yes, this is rebuttable. But then, of course, it'll be an uphill task because consulate won't put a stamp over any document just like that. So it is convenience, right? Now this 85 has now come up with 85A and B, the presumption as to electronic agreements, the presumption as to electronic records and digital signatures, which of course are a development of the growth in the information technology and internet and all these things that we are having these days. Presumption as to digital signature certificates. Most of the younger generation are more aware than even I am as to what is a digital certificate. Now, the court shall presume, unless contrary is proved, that the information listed in a digital signature certificate is correct, except for the information specified as subscriber information, which has not been verified if the certificate was accepted by the subscriber. So that's the genuineness of a digital certificate. So the court shall presume. Now here again, unless the contrary is proved, the one who will deny the genuineness or correctness, he will have to prove. Then presumption as to the certified copies of the foreign judicial records. This is also coming under Section 86. Now this is very important. For the reason we all know that the section says there's a presumption flows upon the judgments which are purported to have been signed by the judicial officers of any foreign country and then attested by those representing the judicial department in that country. But why these provisions here? The reason is, I'll just exemplify from one of my cases. A husband and wife, man and a woman, get married here. The man was a permanent resident of England. The girl goes to England along with her husband. She stays there for good 8 to 9 years, and they have two daughters. One fine day, the husband says, "Come on, let's go to India, let's catch up with your parents." He has no relative in India. Very good idea. The girl really loves it. They come over a holiday and they get back to their house, and the man says that we actually don't want our daughters to be spoiled in England, so I'm probably looking for a school here. I might just settle here in India. Brighter news, the girl is really excited, and he takes the children along so that he can just show up in few schools and arrange for the admission. After a couple of days, the man is lost along with the two daughters. The wife is confused. They inform the police. Then they try and just go around the city, find. He knows nobody. Finally, after 3 days of search, they find that the man has married another woman. It comes as a bolt from the blue for the wife. A police complaint is made because when you have an existing spouse, you cannot remarry. It is adultery. It is bigamy. Sorry, it's bigamy. So when the police comes, the man produces a copy of a judgment of divorce, an ex parte decree of divorce pronounced by a court in England, right? Now, howsoever fraudulently he might have procured that document, because the woman was illiterate and she didn't know anything. But the question is, what is the relevance of that document in India? If you will recall from CPC, foreign judgments come under the section 13. And if somebody was to prove this judgment before a court in India, then how would the court know, or how would the court take its truth, its evidentiary value? That is what 86 throws a light upon. The court may presume that any document purporting to be the certified copy of a judicial record of any country not forming part of India or of Her Majesty's dominions is genuine and accurate if the document purports to be certified in any manner which is certified by any representative of the central government. You know who's a representative of the central government? It is your consulate. It's your consulate office. In for such country, no, which is certified by the representative of the central government in for such country to be the manner commonly in use that country for the certification of the copies of judicial records. An officer who, with respect to any territory or place not forming part of India or Her Majesty's dominions, now this they are talking about UK, is a political agent, therefore, as defined in Section 3 of the General Clauses Act, shall, for the purpose of this section, be deemed to be the representative comprising that territory or place. Now, similarly, Section 87, 88, and 88A, they're talking about books, maps, charts issued by the government, the telegraphic messages. Telegraphic messages are no more in vogue, and then the electronic messages, which are more in vogue. Right, and then presumption as to the due execution of the documents not produced. The court shall presume that every document called for and not produced after notice to produce was attested, stamped and executed in the manner required by law. And presumption as to the 30-year-old document. This is again a very sticky ground for the trial court lawyers, because some people try to overstress it, and some people would try to say that their document is already proved. We don't need to prove anything. We must know, many of the people who are not very well acquainted, or who haven't landed very deeply into the legal research, would say that a will is more than 30 years old, it is already proved, because there's a presumption under section 90, they will say. But the will is never proved. Will is not proved as per section 90. It is always to be proved as per the provisions of section 63 of the Succession Act, read with section 68 of the Evidence Act. It is to be proved by the methods that are laid down there, right? Two witnesses, and then you have to bring them to the witness box and all that stuff. But it is never the case that it's more than 30-year-old. Therefore, there's a presumption. So, what are the documents which are actually presumed? Where any document purporting or proved to be 30 years old is produced from any custody which the court in that particular case considers proper. The first word is proper custody. The court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is that person's handwriting, and in the case of a document executed or attested, it was duly executed and attested by the persons by whom it purports to be executed and attested. Suppose I produce a sale deed made in favor of my grandfather of the year 1960. It is a registered document. It comes from the custody of the registration office. It's a very old document, right? Now, there are a few witnesses mentioned there, but they're all dead. Nobody can bring the witnesses. Nobody knows who their legal heirs are. There's no other way to prove it. In order to avoid these kind of things. Now, this is a document which is duly registered and it has come from a proper custody. Then the court draws a presumption. Now, the word is the court may presume, meaning thereby you can even rebut this document. Remember the very first three definitions that we read in section 4. Never forget that. We usually, when we keep on moving away from the definitions part, we forget the may and shall part, but we should not. Explanation. Documents are said to be in proper custody if they are in place in which and under the care of the person with whom they would naturally be. भाई प्रॉपर कस्टडी वो है जहाँ पे डॉक्यूमेंट पाया ही जाना था, where it was supposed to be. But no custody is improper if it is proved to have had a legitimate origin, or if the circumstances of the particular case are such as to render such origin probable. Now, I'll tell you what is the practical import of this. Suppose floods came in a river. You know, there, Punjab is a land of rivers, and every monsoon, some rivers try and swell. They go out of their bounds and they take many villages along. This time also it happened last year. A lot of villages which were on the bank of river Satluj were washed away, and many of the things just go. Now, what happens? There are several record rooms in those, surroundings. So maybe one of the record room was that of a revenue officer. He was having a map, or a revenue map, a Latta revenue map, or say all the documents which are usually supposed to be in the custody of the circle head, right? Floods came, and everything was washed away. But since the deputy commissioner, and I must tell you, there was this deputy commissioner of SBS Nagar who had issued a prior warning to his officers, to all the people concerned, that the river is going to breach the banks. Therefore, uh, he deputed certain people to repair certain banks, and in the meantime the administration also takes care of the things, that important things are taken away, right? Suppose there's a village just on the bank, and or maybe a headquarter or something, the records are just temporarily shifted to another place. Now somebody takes an objection, sir, this record was not supposed to be in Amritsar, or maybe in Ludhiana, or maybe in Patiala. This record was supposed to be in Jalandhar. And the explanation comes that since there was a huge flood in that district, in order to avoid the loss of this, the government shifted this over here. One reason. Now, the second reason, there was a reorganization of the districts, right? We all know, for political reasons or other reasons, the politicians keep announcing new districts these days, and renaming, re-announcing, then new districts keep coming. So there was a X place which was having the record, but the record was thereafter shifted to place Y. The custodian was X, but now it's Y, right? And an objection is taken, sir. This record could not have been with him. It was supposed to be with the other department. But then they explain that the headquarters got changed and somehow they were shifted here. So that is the explanation which 90 is talking about. It is saying that if somebody is having a proper custody, then of course the presumption flows. But if it is an improper custody on the face of it, but it is explained with a very and the explanation is such that it renders the origin probable, then the presumption will apply. It also says that the explanation applies to section 80 81 also, uh, the gazettes and all that stuff, right? I think it is time that we move to the other important part of the presumptions part, that most of the criminal trials are actually concerned about. These documents, these presumptions, which we just read for the documentary evidence and all that, plays a very important role in the trial courts. For the reason, if a lawyer is aware as to which document the Evidence Act presumes to be there's a presumption in favor of the existence of such fact or document, then he need not waste his time taking futile objections. However, if he is aware as to the confines of that presumption, that in what circumstances he can take the objection, then he must take that objection then away there at the first instance, because in the appellate courts the judges would tend to really make a point as to whether you took an objection at the very first inception. Now let us read a very uh, different part of the Evidence Act, which I say is heavily loaded against the accused as well as some points also against the prosecution. Now, the section 111A says the presumption as to certain offenses. Part 1 says that whatever is mentioned in clause 2, if any area is declared to be a disturbed area, and A, B, C circumstances are shown, this is just the gist of the section. Then there's a presumption that those offenses which are mentioned in subclause 2, they are committed. Now, what are those offenses? Those offenses are all the offenses against the state, 121 and then 121A. This is all conspiracy to commit offenses punishable under 121, and then all the offenses against the state, uh, and then 122, 123. So in some offenses, waging a war against the state and all that stuff. There are certain presumptions. Now, for these reasons, you will know wherever there is any invocation of these provisions in the FIR, waging a war against state. You are a passerby. You were standing and looking at people who were throwing stones or something, right? And somebody comes to you and say, "Here is a brick. Please have this gift from me because this is a souvenir of today's great freedom struggle." And you say, "Please give it to me." The moment you have it in your hand, the presumption flows under this act that from the circumstances that you were standing and you had that material in your hand and police made a recovery, so you are guilty of this offense. That's how dangerous it can be. Right? Let me just read a little bit. Any area declared to be a disturbed area. The very first thing is that the area has to be declared as disturbed area under any enactment for the time being in force, making provision for the suppression of disorder and restoration and maintenance of the public order. For example, I'll tell you, in most of the states where terrorism was a problem, the government came up with these special laws called TADA. याद है ना आप लोगों को? टाडा पोटा, ठीक है? And you would have also heard TADA codes, special codes. So those are very, very draconian laws because it was not possible to deal with with these anti-national activities with the normal laws that we had because the police needed to have some confidence, some extraordinary powers in their hands. So these are the laws that he's here talking about. And any area in which there has been or over a period of more than 1 month extensive disturbance of public peace. अब public peace खराब हो गया 1 महीने से ज़्यादा, and it is shown that such person now, वो किसी accused की बात कर रहा है, such person had been at a place in such area at a time when, and it is shown that such place had been at a place in when firearms or explosives were used at or from that place to attack or resist the members of armed forces or forces charged with the maintenance of public order acting in discharge of their duties, it shall be presumed unless the contrary is shown that such person had committed such offense. आपको याद होगा about a few months ago there was a disturbance in the national capital, and later on, those TV reporters were showing, those, things how they were using from the rooftops and all that stuff. Now that is the kind of thing which is being contemplated here. Now, what are the offenses? The offenses we have already mentioned: 121, 121A, 122, 123. So the presumption is that such person had committed such offense. उसका वहां पाया जाना ही बहुत होगा, but उसके कुछ उसने दे दिए हुए प्री रेक्विजिट्स कि एक स्पेशल एक्ट लगा है, एक डिस्टर्ब्ड एरिया है, स्पेशल एक्ट लगा है, वो डिस्टर्ब्ड एरिया मोर देन 1 month इट इज डिस्टर्ब्ड एंड सच पीपल वर फाउंड, and these are the offenses for which they were charged. So there is a presumption. Now 112 talks about a very interesting presumption. I always nickname it, Daddy, I am your son. So the idea is that a person who was born during the continuance of a valid marriage between his mother and any man. See, half of the culprit in the drafting of this section is nature, because nobody is nobody there can be no confusion about the mother of a child because the mother bears the child. The mother gives birth to the child. The controversy always remains with respect to the father of the child. So it talks about uh, something where a child's father is not traceable, or there is a doubt with respect to a fact as to who is the father of the child, and there is a presumption that such and such man is the father if A, B, C, what this section talks about. Section says during the continuance of a valid marriage. So first thing is valid marriage, and then second thing is within 280 days after dissolution. 280 days after dissolution. And the third condition is mother remains unmarried, right? Shall be a conclusive proof that he's a legitimate son of that man. Supreme Court always refers to this provision saying that the law snubs bastardy. We say, sometimes very casually people say that uh, bastard. Bastard is a child who has no father, his father is not known. So, the object of section 112 is to avoid bastard as dicing. Means that it is no child should be labeled as illegitimate. Therefore, this section gives a presumption. Now, this section is actually been left seriously challenged by the modern developments. What are those modern developments? DNA tracing. Very often in matrimonial cases, we find the applications where somebody claims that he is not the father and he applies for the DNA test of the child and all that stuff, and there the courts are actually really put into difficulty into deciding the parenthood on account of those applications. Now there is another very important development to it. I was just reading one of a very interesting articles written by a law student, and he had very aptly demonstrated the weaknesses of the section in the sense that I haven't seen, but I've just heard about that movie called Vicky Donor. You all must have remembered. So, um, sperm banks and the modern technologies of having these test tube babies and these babies with the help of these technologies. Now this student had actually contemplated an example that suppose the father had put his sperm in the sperm bank, and thereafter uh, he separates and the mother uses that and the baby is born, maybe not within the period specified under 112. He says the child will not get the father will very easily escape this thing because he can take the defense that he had no access. One of the preconditions of 112 is if he can prove that he had no physical access. So, the existence of the precondition of the physical access between husband and wife is also one of the preconditions. So, if he can prove that there was no physical access, he can also dismantle the presumption which flows under the section. So, of course, this is up to the legislation to remedy whatever uh, challenges we are left with under 112. I leave this section to all of you with some food for thought and some dissection because on writing new articles, and then they can contemplate a lot of situations which arise, and ultimately I think it must reach the law commission as to how to remedy those things. Now, then 113 is about proof of cessation of territory, not very we should not be concerned with it right now. But 113A, presumption as to abetment of suicide by a married woman. A great challenge for a criminal lawyer who is representing the defense. Now, when the question is whether the commission of a suicide by a woman had been abetted by her husband, you know, uh, under these provisions, suppose there was an FIR under 498A, cruelty by the husband or his relatives, and in the subsequent days, the woman dies. It becomes really impossible for the husband to get out of the charges of 304B. That is because of the fact that in the murder cases, in the offenses punishable under 302, prosecution still has to prove its story. If there is no eyewitness, it is all the more very difficult. Circumstantial evidence needs to be adduced, a motive needs to be proved, evidence needs to be proved. You have to link the accused with the set of circumstances that there can be no other person but him, where there is no eyewitness. But in the offenses under the punishable under 304B, which is dowry death, this presumption comes to the aid of the prosecution, and it serves very good purpose for the reason that if there was a prior history of the ill treatment of the wife on account of the harassment by the husband or relatives, then the court may presume, with regard to such circumstances, that the suicide had been abetted by her husband. Abetment is defined in section 106, as you all know, abetment to suicide. Suicide itself, although this was not one of our concerns of discussion today, but I'm tempted to share with you the history behind the framing of the section 306 is Lord William Bentinck's reforms. If you would have all, I don't know how many of you would have read history, but there's a very good part um in the historical struggle of Raja Ram Mohan Roy against the Sati, and he was struggling against the Sati system in India, and Lord William Bentinck was the one who took the initiative, and the Britishers particularly abhorred this Indian tradition whereby the Rajput women and many other women were compelled. Rajput women did it on their own. That was known as Jauhar. And you all know the history of the Queen Padmavati and many other brave Rajput ladies. But Sati, by the time Britishers came, was being forced upon the widows. They were being compelled to sit on the burning pyres of their husbands, and that is the backdrop of the offense, which is now punishable under 306 IPC. The abetment is defined in 107, I guess. Now, the thing is that how, in the parlance of backdrop of domestic violence, when the marriage is within 7 years, there's a history of matrimonial discord and the husband harassing, how this provision comes to the aid of the prosecution. Now, the link, the drawing, the line, fine line between may and shall, although it is the word used is may, could not have been shall, because then it would be leaning too much against the accused. But I will tell you, the presumption is really high, although the word used is may. But in criminal trials, unless and until there is a very clear, a very strong case put up by the defense to go and disprove the story led by the prosecution, the chances of survival of the accused are minimal. That is because of this. And the reason behind that is the abysmal conviction rate of uh, the perpetrators of crime against women in the society. But this goes both ways. It cuts size both ways. Sometimes even the innocent are mauled. In one of my cases, uh, the they accused very poor people, laborers, although there was a matrimonial discord. But then the laborers have to go and fetch their daily bread. They have to work. By the time they came back, the woman had hanged herself over with the ceiling fan, and as a result of which, see, this provision was invoked and 304B was invoked. Anyways, so there we come to the presumption of the dowry death. Now, another presumption, 113B, this is what I was talking about. When the question is whether a person has committed the dowry death of a woman, and it is shown that soon before her death, such a woman was subjected to such by such person to cruelty or harassment, or in connection with any demand for dowry, the court shall presume that such person had caused the dowry death. For the purposes of this section, dowry death shall have the same meaning as in section 304B of the Indian Penal Code. So that's how the law tries to strengthen the hands of prosecution against the offenses against women. Now, I will again leave a food for thought. Have these amendments or have these sections really improved the conviction rate? Number one. Number two, if yes, have they really crossed the line? Is it that there too many cases are resulting in conviction where ordinarily the accused may have been um falsely implicated or something like that? Now I come to a very interesting presumption, which is section 114. And I think this would be the last provision, but very interesting one, because section 114 is, although not, you can say it is only illustrative, not exhaustive. So it raises certain presumptions. These this section seems to be based on the common sense. Certain things are very normal to assume and presume, and it seems to be based on common sense. That is my feeling. The court may presume the existence of any fact which it thinks likely to have happened. कुछ ऐसे facts जो कोर्ट समझेगा कि हो चुके हैं, regard being had to the common course of natural events. See, common course of natural events, कि चीज़ें जैसे normally common course में होती हैं, human conduct and public and private business in their relations to the facts of that particular case. This section itself is actually got illustrations, and those illustrations are the one which will actually explain this section. The court may presume A, that a man who is in possession of stolen goods soon after the theft is either the thief or has received the goods knowing them to be stolen unless he can account for his possession. चोरी हुई और थोड़ी ही देर में अलार्म बजा और कुछ दूर भागते हुए चोर को पकड़ा गया गहनों समेत। तो 114A के अंडर प्रिजम्पशन ये है कि ये चोरी उसी ने की है या चोरी का सामान इसने जानबूझ कर लिया हुआ है, अनलेस कि वो इस प्रिजम्पशन को रिबट कर पाए that an accomplice is unworthy of credit unless he is corroborated in material particulars. Somebody has asked a question with respect to the POSCO section 29. Okay, how to rebut this presumption in the bail application stage. I'll come to that later. I use 100 after dealing with this 114. We will deal with that aspect also. सबसे पहला सवाल ये आदमी के पास गहने पाए गए जो चोरी किए हुए हैं, वो प्रिजम्पशन आ गई. सेकंड, an accomplice is unworthy of credit unless he is corroborated in material particulars. अक्सर सेक्शन 114 बी को 133 के साथ कंफ्यूज कर दिया जाता है. 114 बी में कुछ और लिखा है, 133 में जो लिखा है उसे अक्सर कॉन्ट्राडिक्ट और कॉन्ट्राडिक्टरी मान लिया जाता है, राइट. 133 says an accomplice shall be a competent witness against an accused person, and a conviction is not illegal merely because it depends upon the uncorroborated testimony of an accomplice. और 114b बोलता है the accomplice that an accomplice is unworthy of credit unless he is corroborated in material particulars. देखने में लगते हैं लेकिन है नहीं. तो I will leave this question as a food for thought. है बहुत easy है, कुछ नहीं है इसमें, right? तो कुछ ना कुछ मैं रख के जा रहा हूँ, सब कुछ डिस्क्लोज नहीं करके जा रहा, सो दैट आप सब लोग बाद में गूगल करो, देखो, ढूंढो, राइट. बिकॉज क्विज कॉन्टेस्ट में जैसे मज़ा आता है ना, ऐसे ही लॉ में अगर लॉ स्टूडेंट्स को और यंग एडवोकेट्स को रिसर्च की आदत पड़े, अगर आप लोगों को रिसर्च की, डिस्कशन की, और एक चीज़ मैं हमेशा बोलता होता हूँ, हैव यू एवर सीन अ काउ हैविंग इट्स फॉडर? तो वो जुगाली करती थोड़ी देर बाद. तो अगर आप कानून को, हम लोग बीइंग लॉ स्टूडेंट्स एंड प्रैक्टिसिंग लॉ, पढ़ते पढ़ते अगर हम उसको जुगाली करें, उसको सोचें बार बार, तो चीज़ों के जवाब भी आएंगे, एंड इट विल बी गुड फॉर द legal system, the legal industry as well, because we will probably churn out better laws and we will be able to understand the things in a much better way. ठीक है?
Yes, so amazing session, sir. And let's quickly take this question first.
Yes.
Mr. Himanshu Shukla is asking, Section 29 of the POSCO says that the presumption is taken against the accused. Then how to counter this presumption aspect in contesting the bail in POSCO?
Let us read Section 29 of POSCO first. I had POSCO ready with me because probably I was going to say something about it, but हम evidence में इतना घुस गए कि इधर time ही नहीं लगा. Where a person is prosecuted for committing or abetting or attempting to commit any offense, where a person is prosecuted for committing, abetting or attempting, तीन चीजें हैं, to commit any offense under section 3, 5, 7 and 9 of this act, the court shall presume that such person has committed or abetted or attempted to commit the offense as the case may be, unless the contrary is proved. Unless the contrary is proved. I will just like to stress the last word, proved. The thing is, जब आप bail application argue करोगे, when you are arguing a bail application, the offenses or mentioned in the FIR or the allegations mentioned in the FIR have to be taken or prima facie on their face value. Section 29 does not come into play right at the inception कि FIR हुई नहीं और Section 29 के अंदर presumption हो गई. Section 29 comes into play only at the stage of trial. because the prosecution will have to first prove the initial onus. Again, I will refer to Kaliram versus State of Himachal Pradesh, 1984 Supreme Court, AIR 1984 Supreme Court. It says that even in the offences where there is a statutory presumption, the initial onus to prove the facts is always on the prosecution. FIR जब लॉन्च हुई, आप बेल एप्लीकेशन के लिए गए तो फैक्ट्स प्रूव कहाँ से हो गए? Nobody has proved those. I'm not sure if my friend is talking about the anticipatory bail or the regular bail application. But even if he's talking about the regular bail application, it will take a long time for the prosecution to prove those facts. और मान लीजिए कि आपकी बेल एप्लीकेशन किसी ऐसी स्टेज पे आई है जहां पे प्रोसिक्यूट्रिक्स ऑलरेडी स्टेप इन कर चुकी है या अदर आई विटनेसेस आ चुके हैं और प्राइमा फेसाई ये प्रूव हो चुका है, इवन देन your argument should have been that this is a presumption which the trial court will see at the time of the pronouncing of the final judgment. The presumption will operate if the initial burden is discharged by the prosecution. However, it is also possible that the accused may have led some evidence in the defense to dismantle that. So this presumption will not come into play as soon as the offense is alleged to have been committed, because the golden rule in the Indian adversarial system that we are having is that the accused is always presumed to be innocent until proved guilty. तो अगर ये presumption आना ही था, तो it cannot defeat the right of the accused under 438, right? अब तो अब स्पेशल जो स्टैट्यूट्स हैं, फॉर एग्जांपल इवन द एनडीपीएस एक्ट सेक्शन 37 is something which places an embargo to grant regular bail to people who are accused of carrying quantities which are commercial in nature under that act, narcotics act के अंदर, ठीक है? But there are judgments to the extent saying that it is not a complete embargo to the right of the accused to avail of the concession of bail, right? So these will, of course, these presumptions and these things will come, but they are a matter of trial. The word used is proved. Where has the prosecution proved? The prosecution will either prove or may fail to prove at the end of the trial when all the evidence is led, right?
Right, sir. I hope, yeah, that answers. So, audience, if anybody is having any questions, so they can ask, or they can also ask directly from sir. Mr. Ravi Shankar is raising his hand. So I think I should unmute him. Please ask your question if you have, Mr. Ravi Shankar. If you have any question, we'll just wait for 2 to 3 seconds. Okay, I guess he does not have any question.
He's mute.
I am asking to unmute himself.
Yes.
Please do it. He's not responding. Anybody is having any queries, so they can ask or they can write over the YouTube after the session if you have. So we'll try to get back. And also we got good comments over the YouTube, sir, that this was amazing session. And I would also say that there are so many students who never got this opportunity to study these part, so interestingly. So today this was an amazing session, and we often, asked to left this session during our law school days. So today I would say that this was an amazing session. And if anybody would be having query, so you can write over the YouTube link and we'll try to get back and also try to find out the answers which sir asked us to, because that will help us to improve our legal research.
Yes, if somebody will actually go into this 114 illustration B and the apparent conflict with section 133, please write down on my LinkedIn and and just send it to me. So if I get even one answer in response, I will think that my effort was successful, because
Right.
the effort was to stimulate the law students and the younger lawyers to have an interest and inquisitiveness about the evidence. Thank you.
Right. True, sir. So thank you everyone for joining, and thank you so much, sir, for such an wonderful, insightful session, I would say. So thank you again for connecting with Law Seco, and thank you participants. So now I'll sign off, and thank you everyone. And I'll sign
Thank
off,
you.
Anu Bhatnagar,